1. Legal framework governing life insurance. Insurance agents play an essential role in the insurance market. On a daily basis, agents need to be familiar with the legal aspects of insurance. These include insurance products and their specific features, the general form and content of insurance contracts, specific limitations as to the capacity of certain persons to enter into valid insurance contracts, and other important legal limitations. The following chapter provides an overview of the legal framework applicable to insurance and serves as a guide for insurance agents as it relates to the conduct of their professional practice. Insurance agents are not expected to be legal experts in the field of insurance law. However, they can only benefit by being aware of the legal framework and of certain legal technicalities regulating the insurance industry, and hence their professional conduct. In Canada, insurance law is taken from several sources,
particularly Black small square the Canadian Constitution, Black small square common law, Black small square legislation and regulation. The Canadian Constitution takes precedence over all other sources of law, including federal, provincial and territorial legislation. That means that legislation and regulation enacted in the Parliament of Canada and the Parliament of every province and territory must comply with it. Notably, the Canadian Constitution regulates the division of legislative powers between the federal and provincial governments under the Constitution Act, 1867. To the repatriation of the Canadian Constitution from the United Kingdom occurred with the passing of the Constitution Act, 1982, which contains the Canadian Charter of Rights and Freedoms. 3. The Canadian Constitution gives both the federal and provincial governments the power to pass legislation affecting areas or topics under their jurisdiction. Insurance law is considered to be an exclusive provincial matter under the Canadian Constitution. 4. Common law, which originates from England, is law developed by courts based on the decisions of judges, case law, as opposed to statute law, a civil law system based on laws adopted through the legislative process of a state or regulations issued by the executive branch of government of a state. Common law applies everywhere in Canada, except in Quebec, where a system of civil law based on the Civil Code of Quebec is in force. In the common law system, when a statute is passed into law and declared in force, some element of pre-existing common law changes, as required, to avoid any inconsistency. More specifically, the principles applicable to contracts, civil fault, property, common law trusts, and agency are still mostly governed by common law in Canada. In contrast, insurance law has been mostly enacted through legislation passed by provincial and territorial legislatures. This chapter presents an overview of the most important common law rules, statutes and regulations applicable or relevant to a life and health insurance agent's business, life insurance and accident and sickness insurance. 1.1 Life and accident and sickness insurance in its legal context. An insurance contract is an undertaking by one person to indemnify another person against loss or liability for loss in respect of a certain risk or peril to which the object of the insurance may be exposed, or to pay a sum of money or other thing of value upon the happening of a certain event, and includes life insurance. 5. Annuity contracts issued by insurers are considered life insurance contracts under provincial and territorial legislation. 6. 1.1.1 Life insurance. Life insurance covers the risk of one or more persons dying. 1.1.2 Accident and sickness insurance. Accident and sickness insurance may cover loss of health in several ways. Black small square loss, due to accident or sickness, of the ability to work at gainful employment. Disability insurance. Black small square onset of a diagnosed illness covered by the contract, such as cancer, heart attack, or stroke. Critical illness. Black small square accidental death. Black small square accidental dismemberment. Black small square reimbursement of medical fees and drugs. Black small square long-term care needs. 1.1.3 Insurers. Insurance contracts are created and underwritten by business corporations or mutual insurance corporations which are licensed by the government to act as insurers. 1.1.4 Agency relationship. In law, a relationship of delegated authority is called agency, and the individuals in that role are called agents. The person or corporation delegating the authority is called the principal. The principal controls the extent of the delegation. 1.1.5 Agents in common law provinces and territories. The relationship between the insurance company and a life insurance agent, who sells that company's policies, is considered to be that of a principal and agent. In other words, agents act on behalf of the insurance company in selling insurance to clients. The terms and limitations of the agent's authority are outlined in the written contract each agent signs with each company he represents. Insurance agents are either employed by individual insurers or are independent representatives of specific insurance companies to sell that company's products to clients. Agents can be categorized as black small square independent agents, black small square captive agents. 7. 1.1.5.1 Independent agents. Independent agents will have contracts with two or more insurers. Independent agents can sell policies from a number of insurance companies. They generally place their business through managing general agents, MGA, who review applications, submit them to the insurers, collect and allocate commissions. 1.1.5.2 Captive agents. Captive agents represent a single insurer, or are bound by contractual stipulations or employment arrangements to represent a single MGA or insurance marketing entity. The captive agent is an employee of a specific insurance company or affiliate of such company, and only sells that company's products in return for commission. A captive agent may also be a self-employed worker having concluded a distribution agreement with an insurer or an insurer's affiliate with an exclusivity clause. 1.1.6 Managing General Agent, MGA. A managing general agent, MGA, facilitates business between agents, their clients, and insurers by providing some or all of the following services: black small square supporting and assisting an agent in obtaining contracts with insurers, which can include granting authority to an agent to act on behalf of an insurer; black small square processing and tracking agents' business submitted by an agent; black small square providing agents with direct sales support; black small square facilitating the two-way flow of information between the insurer and the agent; black small square pooling of commission payments for the agent from various insurers; black small square facilitating the submission of completed contracting requirements between an agent and an insurer; black small square training agents; black small square providing market conduct compliance supports to insurers; black small square developing products and or assisting in the adjusting of claims on behalf of an insurer. 8. 1.1.7 Agency. An insurance agency is either a corporation or a partnership that holds a license from a regulator or several regulators. An insurance agency must have at least one licensed insurance agent for the same category of insurance for which the insurance agency holds a license. An agent who wants to expand his business by hiring, training and supervising other agents must apply for a license as a corporate agency life license meeting the requirements of the specific province or territory where they intend to operate. 9 A corporate life insurance agency can also submit their business through MGAs. There are a number of conditions regarding certain matters, such as nominees, designated representatives, the agency name, trade name, and registration with the government that a corporate agency must meet to become licensed as a life insurance agency. Any employee of an agency, whether the agency is a corporation or a partnership, who acts as a life insurance agent will need to be licensed. This includes anyone who black small square solicits insurance, black small square obtains or takes an application for insurance, black small square negotiates for or procures insurance, black small square transmits insurance applications and or policies, black small square offers or assumes to act in the negotiation of insurance, black small square negotiates insurance continuance or renewal, black small square collects or receives a premium, black small square develops an illustration for life insurance. An insurance agency must be licensed in British Columbia, Alberta, Saskatchewan, Ontario, Nova Scotia, and Newfoundland and Labrador. 1.1.8 Regulation of insurance and licensing. Given the importance of insurance products to clients and society, It is not surprising that all companies selling life insurance policies in Canada, as well as the various distribution channels and the agents themselves, are heavily regulated and supervised. Provincial and territorial insurance acts contain extensive provisions governing insurers. Provincial and territorial insurance legislation gives designated actuaries extensive powers and responsibilities, including reporting on the financial soundness of a life insurer's business operations. Designated actuaries must belong to the Canadian Institute of Actuaries, and they must conform to its practices and processes. Point 10. Under the provisions of provincial and territorial law, insurance agents must be licensed. The name of the applicable regulatory and statutory framework varies from province to province. The regulation and supervision of life insurance agents will be covered in more detail in Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. From a legal perspective, Table 1.1 provides an overview of the regulatory and statutory framework for the common law provinces and territories. Regulatory and statutory framework for common law provinces and territories. (1.2) General legal principles applicable to a life insurance agent. While each province has its own legislation, the provinces and territories have all based their respective insurance legislation on a model statute created in the 1920s in cooperation with a body called the Uniform Law Conference. 11. This is why the insurance legislation applicable in every Canadian jurisdiction, except Quebec, is very similar. Having more uniform practices and procedures when dealing with life insurance contracts is helpful to clients and insurers, regardless of the province in which they are located. If a policyholder moves to another province after the policy is issued, that province's laws will apply to certain aspects of their estate planning, such as their will. However, the law that applies to the interpretation of an insurance contract, including the naming of beneficiaries, will be the law of the province or territory where the policy was contracted. Point 12. Fortunately, the statutory basis for the creation and treatment of insurance contracts in the various provinces and territories is very similar. The result is consistent treatment of legal principles and their application to the life insurance agent's business. These relevant legal principles that arise from common law or from statutory law statutes are addressed in the following order. Black small square capacity and status of persons. Black small square natural persons, partnerships and legal persons, corporations. Black small square minors and guardians. Black small square powers of attorney, POA. Black small square marriage and common law unions. Black small square divorce and separation. Black small square wills, estates and successions. Black small square trusts and trustees. Black small square bankruptcy. 1.2.1 Capacity and status of persons. In addition to a minimum age, the law requires that anyone, of any age, who is seeking to enter into any contract, must have legal capacity to contract. From a legal standpoint, the concept of capacity relates to a person's ability to provide valid consent. The excerpt below illustrates the legal definition presumed for legal capacity in Ontario. 2. 1. A person who is 18 years of age or more is presumed to be capable of entering into a contract. 2. A person who is 16 years of age or more is presumed to be capable of giving or refusing consent in connection with his or her own personal care. Point 13. The capacity to enter into a contract means the individual is capable of understanding the terms of the contract, and that they are entering into a binding agreement, even if they do not know all the details. Individuals who are mentally incapable lack the legal capacity to give a valid consent, and therefore, to enter into a contract, including an insurance contract. There is no recognized maximum age at which a person is presumed to be incapable of giving valid consent age. Therefore, a 100-year-old person is still presumed by law to have the legal capacity to enter into a contract. 1.2.2 Natural persons, partnerships and legal persons, corporations. It is important to understand that a distinction is made between a natural person, a partnership, and a legal person, corporation. 1.2.2.1 Natural persons, individuals. A natural person is defined as a human being. As stated above, a natural person with legal capacity has the ability to make decisions about their person and property, and to bear the risks and rewards of those decisions. This personal autonomy includes the right to enter into contracts. The term individual is also used in legislation, including taxation, to describe a natural person. 1.2.2.2 Partnerships. A partnership is an arrangement between two or more parties carrying on business together with a view to making a profit. 14 The partners themselves can be individuals or corporations. In an ordinary partnership, all partners may sign the contract on behalf of the partnership, and each partner is financially liable for contracts entered into by other partners on behalf of the partnership. Some partnerships enjoy a statutory limitation on partner liability created by the relevant provincial statute. These are called limited liability partnerships, and they are a common business arrangement for lawyers and accountants. 1.2.2.3 Legal person, corporation. A corporation is a legal person. In other words, it can be described as a separate entity from those that manage or own it. 15 Corporations effectively have most of the property rights of individuals, and so can enter into contracts, and buy, sell, and own all kinds of property. The forms of corporations for businesses differ from the forms for charities and not-for-profits. Business corporations are owned by shareholders, who can be either individuals, other corporations, or partnerships. According to the federal or provincial laws under which they are established, corporations are governed by a board of directors elected by the shareholders. 16 Under the authority of the directors, the corporation can delegate authority to various executive parties called officers, such as the president, vice president, etc. When a corporation seeks to make a contract or transact business, someone must sign on behalf of the corporation. This person is usually referred to as a signing officer. Executive officers, such as the president or secretary, are authorized, usually by a corporate bylaw or a resolution of the board of directors, to represent the company in specific transactions or activities. Insurance applications often call for the signatures of two officers or directors, or ask the person signing to indicate that they are one of the persons, or perhaps the only one, authorized to sign on behalf of the corporation. 1.2.3 Minors and guardians. The rights to legal autonomy referred to above have not yet been acquired by minors, who are persons under what is called the age of majority. The age of majority varies from one province or territory to another. It was formerly age 21, but has been reduced to age 18 in Alberta, Manitoba, Ontario, Prince Edward Island, Quebec, and Saskatchewan. 17 It is age 19 in British Columbia, New Brunswick, Newfoundland and Labrador, Nova Scotia, Northwest Territories, Nunavut, and the Yukon. 18 However, provincial insurance legislation says that, for contracting a policy, but not as a beneficiary receiving death benefits, a person 16 years of age or older has the capacity to contract for insurance on its own behalf. 19 Parents of minors aged 15 and under, without the capacity to contract a life or accident and sickness insurance policy, have an insurable interest in their children and may apply for a life insurance policy in their name. In some provinces, parents also have the right, as guardian of their minor child, to give consent on behalf of the child to conduct some financial transactions. Where it applies, this parental right is conferred by some provincial statute. 20 In their will, parents can appoint a guardian for their minor children and authorize the executor 21 or estate trustee to make payments to such guardian. A guardian of minors may also be appointed by a court. Grandparents, aunts and uncles, or even older siblings or foster parents may apply for and take on this role in the absence or incapacity of the actual parent. A court-appointed guardian is important in insurance practice for two main reasons. First, if a death benefit is payable to a minor, the guardian may be entitled to accept the payment and discharge the insurer from its obligations under the contract. 22 Second, if insurance is being applied for on behalf of a minor as the life insured, and there is no parent, it may be the guardian who will be answering questions on behalf of young minors and completing the application. The guardian will also give consent, on behalf of the minor, to the release of medical information to support the underwriting of the application. If there is no person capable of giving and authorized to give a valid discharge to the insurer for the insurance money, the insurer shall, within 30 days after receiving the evidence required, pay the money and any applicable interest into court to the credit of the minor. 23 In that case, the money will be managed by an official connected with the public. Trustee, if there is no trustee, or court-appointed guardian to receive it. 1.2 For power of attorney, POA, and enduring power of attorney. As part of a life insurance agent's practice, the agent must understand the circumstances and legal mechanisms relating to when the rights of an insurance policy are transmitted to another person. This section discusses the transfer of certain rights and its impact in the field of insurance. To address the risks of becoming unable to look after themselves, personal care, or manage their property, adult individuals may voluntarily appoint a legal representative while they are still capable to represent them and make decisions on their behalf when they are coming to the end of their life, or in the case they become incapable. 1.2 For 1 Power of attorney. A power of attorney is a legal document made by one person who appoints another person, called an attorney, to deal with the business and property of another person, and to make financial and legal decisions on their behalf. A power of attorney can be very specific or very broad. A power of attorney ends if the person who gave the power of attorney becomes mentally incapable. 24 The attorney is also called the agent, and the person appointing the attorney is called the principal. 1.2 For 2 Enduring power of attorney. An enduring power of attorney is a legal document made by one person, the principal, who appoints another person, the attorney or agent, to make financial and legal decisions for the principal. 25 An enduring power of attorney will continue even if the principal becomes mentally incapable of making decisions. To create an enduring power of attorney, the document must be properly signed and must state whether the attorney, the person appointed to make decisions, can act while the person is capable or only while the person is incapable. That the attorney's authority continues despite the incapability of the person. A property power of attorney document, depending on its terms, may come into effect immediately, or it may require someone, such as a doctor or capacity assessor, to trigger its effect, i.e. to determine that the donor of the power has become incapable of managing its own affairs. The attorney, by statute, usually has all the powers required to deal with the owner's property, but not to make a will. 26. In addition, most insurers will refuse a beneficiary designation made by an attorney. 27 Except if a court order is made to the contrary, or in the case of an annuity contract, when there is a transfer of money from another financial institution in the presence of an existing beneficiary designation made with the former financial institution. 28 Otherwise, the attorney would be able to revoke a beneficiary designation made by the principal by transferring monies from one financial institution to another. When it comes to dealing with insurance transactions, insurance agents, before accepting the instructions given by a purported power of attorney, should obtain a certified true copy of the power of attorney from a notary public. 29 and have it reviewed by the insurance company that will be asked to act upon instructions given under its authority. Insurance agents could be asked by trusting clients to act as their power of attorney, an executor, and trustee. This arrangement is not covered by professional errors and omissions insurance, and could put the insurance agent in a conflict of interest with the client and potentially in trouble with the insurance regulator. For these reasons, agents should decline to accept such an appointment, at least without thorough legal advice on the subject beforehand. If an adult becomes incapable and has not appointed a personal representative, a court may appoint someone, including a trust company, to manage their affairs. 30 Trust companies commonly act to manage the finances of incapable adult persons, but will not manage the personal care aspects. Court-appointed guardians of an adult person who has become incapable could transact insurance business concerning an existing policy, such as a term renewal or conversion, or they might buy segregated funds or annuity products as an investment for the incapable, always subject to the authority granted by the terms of the court order appointing them. Unlike enduring powers of attorney, guardianship only comes into effect after a person has been declared incapable. They require the person applying to be appointed as guardian to propose a property management plan for the incapable. Guardians' activities are always subject to review by the court that appointed them. Clients often mistakenly refer to powers of attorney for personal care, PAPC, as living wills. A power of attorney is a legal document in which a specific person is named to act on an individual's behalf. A living will simply addresses your treatment and personal care wishes, and does not need to name anyone or be written in any specific way. Nonetheless, treatment wishes, your living will or advance directive, can still be included in a power of attorney document so that the attorney is aware of them. 1.2.5 Marriage and common law spouse. Insurance agents will often encounter clients who are single, married, or with common law spouses, or who are experiencing a marriage or relationship breakdown. In the latter situation, a client can be obligated to pay spousal and child support. To do a thorough needs analysis, taking these client obligations into account and developing a familiarity with how and when support obligations may arise can be useful. This in turn calls for an understanding of the legal relationships clients may enter into with third parties. It is crucial for agents to understand that the property rights of married spouses usually differ significantly from those of common law spouses when their relationship breaks down. Common law status, no presumed division, 31 is different from married status, presumed division, 32 in this regard. Furthermore, the rights of married spouses to share on an intestacy, the state or condition of dying without a will, which is discussed below, are usually dramatically different from those of common law spouses. Point 33. Marriage is a formal legal status that is acquired and terminated pursuant to federal law. 34 Though the format of the marriage celebration is controlled provincially. Point 35 The legally recognized state of marriage immediately has significant effects on property ownership and civil rights that are subject to provincial and territorial law. It creates both legal rights and obligations. In Canada, any two persons may become married. 36 But individuals may only be formally married to one spouse at a time. Married status is retained until the death of a spouse, the annulment of the marriage, or until a legally valid divorce is granted by court order. Couples may adjust their legal rights before a prenuptial or during a relationship by entering into a domestic or marriage contract with each other. Common law couples can also enter into a domestic contract, sometimes called a cohabitation agreement. Common law status in most provinces and territories is determined by cohabitation in a conjugal or marriage-like relationship for a specific period of time. Rights acquired under common law spousal status vary widely. In most provinces and territories, common law partners can acquire the right to seek spousal support, if needed, upon relationship breakdown. Point 37 In addition to support while living together as a couple, common law spouses are sometimes entitled to claim dependence relief in the event of the death of a spouse who failed to make adequate provision for the other. Spousal status is also very important in pension law, where the right to be a surviving beneficiary will be affected by the existence or non-existence of someone else qualifying as a spouse under the terms of the pension plan. Point 38. Insurance agents can perform a valuable service by advising clients to seek competent legal advice concerning the effects of marriage compared to a common law spouse relationship on their financial and legal arrangements. 1.2.6 Divorce and separation. In the event of divorce or separation, 39 the value of the policy may become subject to the valuation and division of property. Insurance proceeds received from a third party may receive preferential treatment similar to inheritances and gifts, and be excluded from the rebalancing of financial assets. Point 40. Grounds for divorce are controlled by the Divorce Act 41, and the right to spousal and/or child support payments on divorce also arises under the Act. Less commonly, marriages are annulled, meaning they are legally treated as never having been in effect. In either case, the main legal effect is the same: the marriage is dissolved and the divorced or unmarried persons are free to remarry. Since property rights are under provincial jurisdiction, most changes to financial status, except child support resulting from a divorce, arise from provincial and territorial legislation. The effect of a divorce or separation on insurance needs analysis, and beneficiary designation planning is an increasingly complex and important part of insurance law. 1.2.6.1 Family property. All provinces have laws that attempt to determine how spousal wealth and property will be divided when a relationship comes to an end through separation, divorce, or in some cases, death. 42 Division may depend on when the property was acquired, and from what source. 43 The phrase family property variously implies property that was acquired during the marriage, or is used or enjoyed by the family of married spouses, or that generates income that supports the family. Ownership of family property is presumed subject to equal division when the married spousal relationship breaks down, but subject to a judge's discretion. In contrast, property that was acquired prior to the marriage or relationship, or that came from an inheritance during the marriage, usually gets protection from division. The rules are specific to the particular jurisdiction where the couple resides when the relationship ends. Rights to spousal support are separate from, and additional to, a right of property division. All of these rights given by statute may be modified by competent adults who enter into a contract by which they modify or even give up rights. 1.2.7 Wills, estates and successions. The term succession law applies to the body of provincial law that deals with deceased persons' estates and the rules governing property passing as a result of a death. The collection of property and property rights that the deceased owned is referred to as their estate. All the provinces and territories of Canada permit an individual to prepare a will leaving their estate to whomever they wish. 44. People usually also appoint a person to be in charge of the estate. If appointed under a will, that person may be referred to as the executor, male, or executrix, female, or estate trustee, gender neutral. As the person who controls the estate, they have the legal obligation to pay the debts, including taxes, of the deceased from estate assets, and to manage and distribute the remaining assets in accordance with the terms of the will. Not all property owned by an individual is controlled by their will. Ownership of property held in joint tenancy, 45, with one or more persons usually passes outside the will. Registered plans with a named beneficiary, including registered retirement savings plans, RRSP, registered retirement income funds, RRIF, and tax-free savings plans, TFSA, pass directly to the named beneficiary. Life insurance payable to a named beneficiary also passes outside the will to the named beneficiary. In contrast, life insurance payable to the estate of the policyholder is disposed of under the terms of the will. Surviving spouses under pension law also obtain rights that have priority over designated beneficiaries, legatees, and heirs, which are also received outside the will or the estate. Coupled with will making, there are strong laws to protect those to whom the deceased owed legal or moral obligations of support. Financially dependent persons, such as a surviving spouse or children, can sue the estate for support if the deceased person owed them a duty of support and failed to make adequate provision. The laws governing this, generically called Dependents Relief Legislation 46, give dependents priority before any disposition or distribution under the deceased's will is made. The prior rights of financial dependents and spouses allow them to be adequately provided for even though they may receive life insurance as a named beneficiary. Such insurance may be considered part of the estate and made subject to an order for the support of dependents. 1.2.7.1 Testate and intestate successions. Clients may or may not have a valid will when they die. If they do, they are said to have died testate with a will. If there is no will, the client is said to have died intestate, 47. Sometimes there is a complete will, or a partial will, but no named executor able and willing to act. If there is no will or no willing and able executor, someone must apply to the court to be put in charge of the estate. This person will also be recognized as an administrator or estate trustee. This is usually one or more of the adult beneficiaries who will be inheriting the estate. When there is no will, the estate trustee will distribute the estate in accordance with the applicable provincial rules on intestacy. 48. If there is a will, the executor will distribute the estate, after the payment of the debts, according to the will. Separation of married partners has no effect on a will, and signing a separation agreement may allow alimony claims to be made against the other spouse's estate, but it does not usually affect voluntary gifts made by will or the designation of beneficiaries. If clients wish to disinherit a former legal spouse, marriage, after separation, they need to change their will and their beneficiary designations, and sign a separation agreement. Divorce does not revoke a will either. The will is interpreted as if the former spouse had predeceased the testator. Only the provisions in the will that refer to the spouse are revoked. 49. Likewise, a divorce does not revoke the designated beneficiaries, 50 except in Quebec. 51. In addition, it is important to know that a will made before marriage is automatically revoked upon marriage, unless the will was made with the marriage in mind, with a statement making reference to the upcoming marriage and the name of the spouse. 52. If a policyholder's beneficiary designations contained in a will are revoked, and there is no valid beneficiary designation, the insurance or registered plan proceeds will become payable to the policyholder's estate. When the policyholder dies without a will, the estate will be distributed according to the provincial law that determines who inherits on intestacy. 53. Insurance agents should not hesitate to direct clients to the client's own legal advisors to provide for estate planning, or to manage specific life events such as separation or dissolution of marriage. 1.2.8 Trusts and Trustees. Trusts established during life of the settlor. 54 are called inter vivos trusts, between living people. Trusts established upon, and as a consequence of, someone's death are called testamentary trusts. While guardians and powers of attorney 55 have certain powers over a person's property, they do not take title to the property. In contrast, trustees have legal title, as opposed to equitable title or beneficial ownership, to the property given to them in trust. While a power of attorney may choose to act, they generally do not have to do so and may resign. In contrast, once a trust has been created, a trustee is already under a positive legal obligation to act as and when the need arises. A trust is therefore arguably a form of property management for the benefit of the beneficiaries of the trust, considered vulnerable. Put another way, trusts are simply a form of surrogate ownership, where the trustee has title to, and control over, the trust property with the obligation to distribute them to the beneficiaries of the trust. Example: Rob gives money to his lawyer, to be used towards Rob's purchase of a house. The money is put into the lawyer's trust account, so only he has control over it, and it is in his name. But there is no doubt in anyone's mind about who the money belongs to, or what it is to be used for. If the lawyer dies or goes bankrupt, the trust money is unaffected, because it does not belong beneficially to the lawyer. Insurance proceeds can be used to create a trust fund, or to enhance the size of an existing one. Trustees can own any type of property that individuals can, so they can also hold an insurance policy, pay the premiums from trust monies, as long as necessary, and then either transfer ownership of the policy to the beneficiary, or collect and handle the proceeds of the insurance in accordance with the terms of the trust, i.e. as the person who set up the trust directed. Insurance agents should not hesitate to direct clients to the client's own legal advisors to provide for trust and estate planning. 1.2.9 Bankruptcy. Individuals may incur more debt than they are ever able to repay. They may have assets and income, but if they are unable to meet their financial obligations as they fall due, they are insolvent. If some creditor formally pushes them to pay a debt, they may decide to make a formal declaration of bankruptcy, or be adjudged bankrupt. 56 Either case leads to the appointment of a bankruptcy trustee. The trustee in bankruptcy collects the available assets of the bankrupt person and uses them to the benefit of the bankrupt's creditors according to the rules in the Bankruptcy and Insolvency Act. Similar policy considerations also underpin laws that provide for particular legal protections to apply to life insurance proceeds. Life insurance or financial products that qualify as life insurance, including life annuities and segregated funds, may qualify for special protection against creditors in the event of an insolvency or bankruptcy of the policyholder. As discussed earlier, when an individual dies, the first duty of the estate representatives is to pay the debts and taxes owed by the deceased. It is entirely possible that there will not be enough money in the estate for all the creditors to be paid. In such a case, the persons named in the deceased individuals will receive nothing, and they may simply refuse the inheritance. An estate might be bankrupt, just as an individual can be bankrupt during their lifetime. However, provincial insurance legislation states that insurance proceeds payable to beneficiaries do not form part of the insured's estate. 57 Since they are not part of the estate, they are not subject to control by the estate's creditors. In addition, while a designation in favor of a spouse, child, grandchild, or parent of a person whose life is insured, or any of them, is in effect, the insurance money and the rights and interests of the insured therein and in the contract are exempt from execution or seizure. 58. Asset protection is one reason that agents usually advise clients to name direct beneficiaries rather than their estate. Another opportunity to create asset protection, even for beneficiaries outside the protected family class, is the irrevocable beneficiary designation. In such a situation, the policy itself, which could have substantial cash values, is also not subject to seizure and cancellation by execution. Creditors. 59. Generally, the property divisible among creditors must not include any property that is exempt from execution or seizure under any laws applicable in the province within which the property is situated and within which the bankrupt resides. 60. For beneficiaries to be protected, there must be specific provincial legislation which clearly states that a specific insurance product is exempt from seizure and under what circumstances. For example, in Ontario, the Insurance Act clearly states that when an insured makes an irrevocable beneficiary designation, the insurance money will not be subject to the control of the insured's creditors. 61. The extent of the beneficiary's protection is limited to the terms of the provincial legislation which provides for such protection. 62. The use of irrevocable beneficiary designation is not commonplace, and agents should not hesitate to invite their clients to consult with legal advisors should the facts in a specific case require specialized attention. Please consult Chapter 2 for additional information on this topic. Pension funds, including LIRA, LIF, and annuities purchased with pension funds money, are also generally exempted from seizures. 63. In some jurisdictions, registered products, such as RRSP and RRIF, are exempt from seizure, even without beneficiary designation, and even if issued by financial institutions other than life insurance companies. 64. It is also important to mention that in every Canadian jurisdiction, other than Quebec, it is possible for the owner of certain registered products, such as RRSP, RRIF, and TFSA, to designate a beneficiary. In that case, the beneficiary will receive the death benefit outside of the estate and avoid probate fees. 65. 1.3 Legal principles required for the validity of the contract. A contract or agreement established under common law principles is enforceable. It must be created by one or more parties with the shared intention of entering into a binding agreement. This is an important part of contracts. They are often described as a meeting of the minds, meaning that unless and until both sides are in agreement, there is no contract. The subject matter of the contract must also be acceptable under shared values described as public policy, which are the principles on which social laws are based. Chapter 2 Insurance Policy Provisions takes a more insurance policy specific approach, while this section is more generic. Example: Ralph found a criminal who was willing to commit arson so Ralph could collect fire insurance money on a commercial property. Ralph paid the criminal $10,000, but the criminal promptly gambled the money away. Ralph could not get his money back. The contract was unenforceable. It was void because it was against public policy. 1.3.1 Civil Fault. Civil fault is an action or omission which causes someone loss or harm for which the wrongdoer is liable. A breach of the privacy obligations of an agent could lead to a civil action against the agent in torts. The loss or harm is therefore not limited to the physical loss and may include the following damages: black small square injury to reputation, defamation; black small square emotional injury; black small square economic injury; black small square violations of privacy 66; black small square violations of property; black small square violations of constitutional neglect. If claiming to be the victim of civil wrongdoing, a client could initiate civil litigation against the agent or insurer depending on the case. 1.3.2 Limitation Periods. A limitation period is a timeframe during which a court action must be started, or the right to sue is lost forever. Once someone discovers that civil wrongdoing has been done to them, the limitation period clock starts ticking. There are different limitation periods for different civil wrongdoing, and each jurisdiction dictates this. 67 It can occasionally take some time before damage, like hidden faulty building construction, for example, is discovered. In other cases, knowledge of the wrong is immediate. Prompt legal advice is always advisable. John died. His beneficiary Betty filed a claim for a life insurance benefit. The insurer refused to pay, claiming John had misrepresented his health on his application. Betty will only have a finite length of time to launch a lawsuit. 68. 1 point for public insurance and retirement regimes. Over time, both the federal and provincial levels of government have set up programs that contribute to the social safety net for citizens and others. It is important that insurance agents monitor changes to such programs to be able to guide their clients with up-to-date information. Insurance agents need to understand all aspects of these public insurance and retirement regimes, which may affect or be available to their clients, so that any needs analysis or advice provided takes into account relevant information and facilitates the coordination of benefits. When spouses are both entitled to benefits for themselves and their family members under a privately sponsored health, drug, or group dental plan, care must be taken to avoid double payment for the same expense. To prevent overpayment, the benefit companies apply coordination of benefits so that one benefit plan pays first, while the second plan pays only the unpaid balances remaining. The phrase is also used when considering benefits provided by a provincial health plan and a private insurer. Private coverage is only supposed to address services not covered by a provincial plan. An example would be private insurance paying for a semi-private hospital room if ward accommodation is the basic provincial standard. Another example might be private insurance payment for a very expensive prescription drug not covered by the province on their list of publicly funded drugs. 69. 1.4.1 Federally sponsored or facilitated programs. On a federal level, the following will be addressed: Black Small Square Canada Pension Plan, CPP, and Disability; Black Small Square Old Age Security, OAS, and Guaranteed Income Supplement, GIS; Black Small Square Employment Insurance, EI. The purpose of the CPP, OAS, and GIS is to provide a secure, modest base upon which to build additional retirement income. These federally sponsored plans are not intended to meet all the retirement income needs of Canadians. It is each person's responsibility to look at their own circumstances to decide what level of income is right for them and develop their own retirement plan. Agents should be able to guide their clients with other insurance products which may be used to achieve retirement objectives, such as tax planning, estate planning, financial security, investment and/or creditor protection, such as RRSPs, annuities, life insurance, etc. The purpose of the Employment Insurance (EI) program is to provide temporary income support to those who are between jobs, cannot work for reasons of sickness, childbirth, or parenting, or who are providing care or support to a family member who is gravely ill with a significant risk of death. Agents should be able to guide their clients with other insurance products which may supplement EI should benefits offered under this federal plan be insufficient to meet the client's needs. Such products generally include but are not limited to disability, accidental death, and dismemberment and long-term care insurance. 1.4.1.1 Canada Pension Plan, CPP, and disability. Individuals who are employed or self-employed in Canada contribute to a mandatory pension plan. 70 The CPP is funded by contributions, and not by the government through duties and taxes. Employers also contribute an equal amount for their employees. The contributions of the employer are deductible on the employer's income tax return, and the pension is taxable income for the employee when received. Incomes over the maximum pensionable earnings do not contribute to CPP, so high-income individuals must seek other forms of retirement security. An individual may begin drawing a reduced pension any time, after age 60, or an enhanced pension as of age 70. CPP contributors may also draw a disability benefit if they become permanently and totally disabled. There are also provisions for a modest death benefit to assist with funeral expenses, and survivor benefits for spouses and children. Spouses may split CPP benefits to enable income splitting in retirement. Benefits may also be assigned as part of the property settlement should the marriage break down. 1.4.1.2 Old Age Security, OAS, and Guaranteed Income Supplement, GIS. Unlike the CPP, Old Age Security, OAS, is non-contributory and is government-funded through duties and taxes. OAS pension benefits are considered taxable income for the pensioner. The benefit amount depends on how long the resident has been in Canada since age 18, spousal status, and pensioner status of the other spouse. 71. The Guaranteed Income Supplement, GIS, is a non-taxable supplement for those already getting the OAS pension. 1.4.1.3 Employment Insurance. Persons employed in Canada must also contribute through payroll earnings to a plan that provides financial support during periods of unemployment. Employment Insurance, EI, provides temporary financial assistance to unemployed Canadians who have lost their job through no fault of their own, while they look for work or upgrade their skills. 72. The individual must have a minimum number of insurable hours of employment before becoming eligible for benefits, and the benefit payable will depend on the number of hours worked. Self-employed individuals are not eligible for EI benefits. Unemployed individuals seeking work must file a biweekly report of any earnings they did manage to acquire, perhaps through part-time work or even self-employment. Depending on the duration of unemployment, the amount of benefit paid, and money earned by the end of the year, some of the benefits received may have to be repaid as part of income tax filing obligations. 1.4.2 Provincially or territorially sponsored or facilitated programs. On a provincial level, the following will be addressed. Black Small Square No-Fault Automobile Insurance. Black Small Square Workers' Compensation. Black Small Square Universal Health Care and Drug Plan. The purpose of such plans varies, but all provide public coverage to individuals in certain circumstances and avoid lawsuits. No-Fault Automobile Insurance is a provincially sponsored plan with which a resident of the province, the policyholder, and his or her passengers are not only reimbursed by the policyholder's own insurance company without proof of fault, but also restricted in the right to seek recovery through the legal system for losses caused by other parties. This type of public plan may be supplemented with private insurance products such as disability, accidental death and dismemberment, and long-term care benefits. Workers' compensation was the first social program to be introduced in Canada. Workers' groups supported the program, as did employers who hoped to provide disability benefits to workers and thereby avoid lawsuits. Workers' compensation is a provincial responsibility, and the rules vary from province to province. Workers may supplement such public insurance with private coverage through products which include, but are not limited to disability, accidental death, and dismemberment, and long-term care benefits. The purpose of a universal health care and drug plan is to provide a specified package of benefits to all members of a society with the end goal of providing financial risk protection, improved access to health services, prescription drugs, and improved health outcomes. Such public plans may be supplemented with additional private coverage through disability, critical illness, and long-term care benefits. 1.4.2.1 No-Fault Automobile Insurance. Despite the name, no-fault insurance is still very much concerned with who caused an accident, so as to decide who pays for direct compensation and property damage. The big change from traditional, fault-based litigation is that insured persons look to their own insurance company for accident benefits, such as health care and income replacement. Fault is determined by the insurance companies using a series of allocation rules based on typical accident fact situations. British Columbia, Saskatchewan, Manitoba, and Quebec have government-run insurance programs, whereby the province provides the basic insurance benefits, which vary from one jurisdiction to another, in the event of an accident, and private insurers compete to sell top-up coverage. 73. In other provinces, these rules have been incorporated into provincial law as a regulation adopted under the Insurance Act. For example, in New Brunswick the Insurance Act has a regulation named Fault Determination Regulation, Insurance Act. 74. Agents should become familiar with the regulations applicable to the jurisdiction in which they sell insurance products. 75. 1.4.2.2 Workers' compensation. Compensation and rehabilitation benefits are available to the workers on a no-fault basis, i.e., without any finding of fault with them or the employer. These are managed on a provincial level. Benefits payments are secure because they are funded by mandatory employer contributions through a payroll tax. In exchange to being entitled to these benefits, workers give up the right to sue their employers. 76. 1.4.2.3 Universal Health Care and Drug Plan. Canadians with valid provincial health care enrollment enjoy a form of universal health care anywhere in Canada, with medically necessary care and treatment available through publicly funded doctors and hospitals. There is not one unified plan, but 13 separate provincial and territorial plans coordinated under agreed-upon standards, defined under federal legislation, the Canada Health Act. 77 The provinces and territories remain responsible for the management, organization, and delivery of healthcare services. The provincial and territorial governments also provide various prescription drug coverage benefits, 78 paying some or all defined drug costs for those with low income, the disabled, and seniors over 65, and residents of long-term care homes and hospitals. 1.5 Other relevant provincial and territorial legislation. For life insurance agents. In addition to the basic legal framework and contract formation discussed above, there are a number of important legal considerations that agents must take note of while dealing with life and health insurance contracts. It is very important that agents remain continually aware of the obligations which apply to them. Poor awareness of such obligations may hurt clients and have severe consequences for an agent, including stiff monetary penalties and even the revocation of the agent's license. Such obligations are described in greater detail in Chapter 4 Rules and Principles governing the activities of life insurance agents and accident and sickness insurance agents. 1.5.1 Privacy Act. In the course of carrying out their business, life insurance agents have access to a great deal of personal information about their clients. How they handle that information is regulated by privacy legislation. The federal government has appointed a privacy commissioner to investigate complaints about breaches of privacy under federal jurisdiction and make his findings public. The Commissioner has authority under two laws. The first one is the Privacy Act, 79, which is federal legislation governing how the federal government and its agencies handle personal information. 1.5.1.1 Personal Information Protection and Electronic Documents Act, PIPEDA. More important for insurance agents is the second privacy statute, the Personal Information Protection and Electronic Documents Act, PIPEDA. Point 80 PIPEDA sets out ground rules for how businesses and other organizations may collect, use or disclose personal information in the course of commercial activities. PIPEDA also controls how federally regulated businesses must act in handling employee personal information. If provinces have chosen to pass laws similar to PIPEDA, those laws take precedence in the province. 3 provinces have passed laws for privacy, 81 and 3 others have adopted legislation protection personal health information. Point 82. PIPEDA ensures that only information that is needed and relevant to conduct a business transaction should be collected. Once the need for the information is over, the information should be disposed of in a careful fashion. The provinces have also appointed privacy commissioners, whose mandate is connected to matters under provincial or municipal jurisdiction. Their mandate is especially directed at maintaining the privacy of health care information. Privacy commissioners are also involved with freedom of information activities on behalf of citizens seeking to obtain publicly held or governmental information. In the other Canadian jurisdictions, PIPEDA applies. 1.5.2 Human rights legislation. Under provincial and federal human rights legislation, discrimination on the basis of a number of personal and/or group attributes and characteristics is prohibited. On a federal level, such legislation includes the Canadian Human Rights Act 83, and there is various provincial legislation to the same effect. Point 80 For discrimination is forbidden on the basis of gender, religion, skin color, national origin, family status, marital status, sexual orientation, and age. Insurers, however, are permitted to discriminate in providing insurance coverage as long as they can justify it on reasonable and bona fide grounds. Point 85. 1.6 Other relevant federal legislation for life insurance agents. Life insurance agents should take the following legislation into consideration when dealing with clients and carrying out their business. 1.6.1 Criminal Code. The Criminal Code is a Canadian federal law defining behavior and actions that constitute a crime, and are generally more serious offenses, including those that may result in jail time as well as fines. Point 86. 1.6.2 Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCMLTFA. This important Canadian law aims at detecting individuals and corporations involved in criminal activity and preventing them from getting their illegally obtained money into the banking system. Insurance agents are part of the process since insurance products can be used as wealth creation, storage, and transfer tools. Reporting suspicious transactions and the suspected possession of terrorist property, money, or investments remains the personal responsibility of every insurance agent. Agents also face severe personal penalties and even imprisonment if they fail to report. Suspected money laundering or terrorist financing must be reported to an agency called the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, who will monitor and investigate. Point 87 This act is covered in more details in the section Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, in Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. 1.6.3 National Do Not Call List, DNCL. The federal government has created a system, under the Canadian Radio Television and Telecommunications Commission, CRTC, 88 whereby clients may register their phone numbers and request that telemarketers do not call them. Calls to businesses are not prohibited. These rules apply to life insurance agents who call clients and prospective clients. Agents making their own telemarketing calls must register and subscribe to the National DNCL. If agents hire telemarketers to make calls on their behalf, then the telemarketers must comply with the national DNCL. 1.6 for anti-spam legislation. Effective July 1, 2014, federal legislation known generically as the Canadian Anti-Spam Legislation, CASL, 89 came into effect. CASL prohibits the sending of commercial electronic message, CEM, if the sender does not first have the recipient's consent. The CEM must have prescribed consent and a mechanism to unsubscribe. A request to unsubscribe must be honored immediately and no later than within 10 business days. Agents should establish and document, from their very first dealings with clients, the practices to be followed when dealing with their clients' personal information. Finally, it is important to mention the Genetic Non-Discrimination Act, SC 2017, C3, whose constitutional validity the Supreme Court of Canada has just confirmed. 90 in particular, this law prohibits anyone from forcing a person to undergo a genetic test as a prerequisite for providing them with goods or services, for entering into or maintaining a contract with them, or for offering or maintaining specific terms within the framework of contract. The law contains the same prohibition on the communication of results of a genetic test. Chapter 2, Insurance Policy Provisions. Competency Component. Black small square integrate into practice the legal aspects of insurance and annuity contracts. Competency Subcomponents. Black small square characterize the parties involved in the contract. Black small square contextualize the rules relating to the contract's formation, taking effect, reinstatement and termination. Black small square explain the main provisions and clauses of an insurance or annuity contract. Ethics and Professional Practice. Chapter 2, Insurance Policy Provisions. 34.